ऑनरेबल सुप्रीम कोर्ट ऑफ इंडिया में केस चल रहा है SC ST सब क्लासिफिकेशन स्टेटस को लेकर, कोटा को लेकर। इसमें आज इस वीडियो में आप देखोगे के वेणुगोपाल सीनियर एडवोकेट, जो कि 2004 में चिन्नैया जजमेंट में भी अपीयर हुए थे। चिन्नैया जजमेंट क्या था, जिसके बारे में पहले भी बता चुका हूँ कि मैं ऐसा जजमेंट था जिसमें ऑनरेबल सुप्रीम कोर्ट के 5 जजेस बेंच ने ये कहा था कि स्टेट के पास पावर नहीं है सब क्लासिफिकेशन करने की। उसी को लेकर अब 7 जजेस बेंच बिठाई गई है, जो उसी क्वेश्चन को फिर से देख रही है। बैकग्राउंड क्या था इस केस का कि पंजाब गवर्नमेंट ने एक सर्कुलर पास किया था, एक इशू किया था सर्कुलर, जिसमें उन्होंने 50% जो SC में कोटा में बाल्मीकिस और mazhabi सिख्स को रिजर्वेशन दी थी। लेकिन वो जब चैलेंज हुआ हाई कोर्ट में, तो हाई कोर्ट ने उस सर्कुलर को स्टक डाउन कर दिया। उसके बाद जब सुप्रीम कोर्ट के पास ये पहुंचा, तो सुप्रीम कोर्ट ने कहा कि चिन्हैया जजमेंट में जब ये पहले ही डिसाइड हो चुका 5 जजेस बेंच के द्वारा, तो अब इससे बड़ी बेंच चाहिए हमें इसको डिसाइड करने के लिए। दैट्स वाई 7 जजेस बेंच बनी थी और 7 जजेस बेंच में अब इस केस को सुना जा रहा है। अब उसी को लेकर इस वीडियो में आप देखेंगे के वेणुगोपाल सीनियर एडवोकेट जो हैं वो इस पर आर्ग्यू करेंगे, जो पहले भी अपीयर हुए हैं 2004 में चिन्हैया जजमेंट के जो आई थी उसमें वो अपीयर हुए हैं इस केस पे। और सुप्रीम कोर्ट की मैं अपडेट्स डालता रहा हूँ चैनल पे, तो आगे भी आपको अपडेट्स मिलते रहेंगे। उसके लिए आप चैनल सब्सक्राइब कर दें और बेल आइकॉन पर क्लिक करें, ताकि आपको अपडेट्स मिलते रहें लीगल टॉपिक्स को लेकर और सुप्रीम कोर्ट की हियरिंग को लेकर।
I had appeared before the 5 judges in the Andhra Pradesh High Court in Chinnahia. They had upheld the subcategorization of 61 scheduled castes into 4 divisions based upon their advancement over the years. And they had given Millards 7% to the weakest among the weak, 6% Millards of the jobs and educational institutions seats to Millards another group, and to the best, to the highest among them, 1%, 1%. This was upheld on the basis of categorization was permissible. Chinnahia Millards reversed it and said that the whole of them being a homogeneous group, this cannot be done. Now, the basis of Millard's subcategorization was an elaborate 200-page Millard's investigative Millard's report of Justice Ramachandra Raju. And the Judge Millard's, after enamored this, found that there is vast disparities between the different groups in the 61 Millard's subcastes, some of them being Millard's workers in leather, the scavenging, and Millard's nomadic and so on, who had been excluded to a very great extent, so that the fruits Millards of reservation had been taken over by more advanced ones among Millards, the entire group of 61. And that is the basis on which, based on the comparative advancement Millard of the groups, he had grouped it into 61 into 4 groups and had given varied Millard representation. Now, this is Millard what was held by Chinnahia, and Millard was reversed by the Supreme Court of India. Now, my submission to your lordships is this. Article 14 of the Constitution, Millard, is a golden thread which runs right through the entire provisions of the Constitution. At the very inception of the Constitution, the founding fathers had examined the disabilities of various groups and had provided in the original Constitution itself for affirmative action for the purpose of their upliftment. And therefore, Lord, if your lordships would be pleased to take my written submissions, which is a short 10 pages.
1G.
It is
where will we find them? Where will we find them, Mr. Venugopal?
volume 1, capital G, my lord.
Yes. Just a second.
Your lordships inclined.
Give us just a moment so that all of us can access it.
1G.
Yes, it's page 1.
Your Lordship will find, if your Lordship should be pleased to go to page 5, the various steps taken, my lords, by the founding fathers themselves to ensure that unequals are treated equally with the rest of their category to which they belong. And at the bottom in paragraph, my lords, 11 of page 5, your Lordship will find Article 15.3, special provision for women and children. Your Lordship have got it, my lords. Para 11. I hope your Lordships have it. Para 11, my lords, at page 5.
Yes, Mr. Chairman.
And then para 12, 15.4, that is the backward classes. Then it goes on like that. 15.5, scheduled caste, scheduled tribes, admission to private institutions. Then economically weaker sections, 15.6, which your Lordships upheld, 10%, my lord, in addition to the 50%, and 15.6b, 16.4, 16.4a, 16.4b, 16.6, 17, untouchability, and 18, which is, my lords, against against titles to citizens, which your Lordship has held in one of the judgments, Indian young lawyers, that some people are being placed above the others, and this cannot be permissible, and that is why. Therefore, so far as, my lords, the benefits are concerned, it is in regard to the state has given benefits socially, educationally, in employment, and politically as well. And your Lordships will find that politically, it is in Article, my lord, when the panchayats were introduced, in para 22, that is seats for scheduled castes, scheduled tribes in panchayats. Similarly, my lords, in regard to, my lords, the municipalities, then the benefit, my lords, to women, where they are given 1/3 of the total seats, rotation of the chairman, where the women will be given, that also. Now, this is, my lords, the broad basis on which the Constitution had approached, my lords, these inequalities which have been prevailing in the population, my lords, of this country. Thereafter, my lords, they found during the course of the working of the Constitution that there were certain, my lords, classes which stood again deprived of what would be, my lords, an equal treatment under the Constitution. And therefore, my lord, amendments were made. And that is how, my lords, so far as the benefits to scheduled caste, scheduled tribes, to entry to, my lords, the educational institutions, including, my lord, private institutions, was provided for. Economically weaker sections were given 10%, irrespective of religion, caste, creed, etc. Now, similarly, very many other amendments. Now, in this background, I would request your Lordships to go to Article 28.2 of the Constitution.
Or 38.2, right? 38.2.
28.2. And this, I say, is a fulcrum on which the entirety of, my lord, the problem is to be approached.